On behalf of my office bearers, managing committee and law and representation committee, I welcome today's chief guest, Honorable Justice Shri Ujjal Bhuyan from Bombay High Court. Friends, today we have an icing on the cake moment for all of us, because when we approached the Lordship to address our members for today's event, he not only readily agreed to it, but also expressed his desire to listen to the speaker and also speak on Calcutta Club Limited judgment at the end. Lordship, we are overwhelmed by your presence. Uh, I also welcome today's speaker, Senior Advocate Vikram Nankani sir. He is a stalwart in indirect tax, and we could not think of anyone else but him for today's topic. Vikram sir, let me confess, I am a fan of yours. More than a decade ago, when I was still a student, I had an opportunity to attend one of your sessions. I was awestruck then, and I'm awestruck now as well. This is certainly my fanboy moment. I would also like to welcome a galaxy of past presidents present here. PC Joshi sir is here, Nikita madam is here, Hiten Shah is here. Lot- the list is getting updated as and when they are entering. And of course, all the members who are present here virtually. Thank you very much for attending today's event. Now, I request Janak Bhai Wagani, who is the chairman of the Law and Representation Committee, to say a few words. Janak sir, please.
We don't have network connection with Janak Bhai.
Okay, okay. Okay, so before we go to Janak Bhai, for the benefit of the members, I would like to share my screen here. I hope you can see my screen. In the current pandemic scenario, as we know, this year is not about growing, but this year is more about consolidating. And this is the reason GSTPAM has tied up with Cosmos Cooperative Bank, and we would be offering unsecured collateral free security loan or overdraft facility for the members of the association at 8.9% per annum. So this is especially for the members of our association. We understand many of us must be going through a strict liquidity phase right now. So this would definitely help all our members in passing through the tough time, which almost all of us are going through. So this is what I would like to. I wanted to introduce this new feature of our association to all the members. Thank you. Now, do
Janak
we
Bhai
have?
is here. Janak Bhai is here.
I'm there. Hello.
Yes, Janak bhai.
Good morning, everybody. Namaskar. Jai Shri Krishna. Jai Jinendra. Jai Swaminarayan. President Mr. Raj, our chief guest of today, Honorable Sri Ujjwal Bhuyan, Judge Bombay High Court, and today's speaker Sri Vikram Nankani, Sir Advocate, Senior Advocate, and our past presidents, seniors in profession, and friends. I welcome all you to this inaugural study circle meeting of the year 2020-21. I thank our distinguished guest, Honorable Bhuyan Sir, for agreeing to be the chief guest and blessed us today, and also thank Vikram Sir to discuss and enlighten us on celebrity judgment of larger bench of Supreme Court in case of Calcutta Club, although given under earlier law, but may have applications to the GST also. Thank you, sir, both of you, sir. And holding of the study circle meeting is the one of the activity of our association, continued since our foundation, that is more than 60 years, sir. And it is for the benefit of everybody, free of charge for the members and the public. We were holding this study circle in our library, Mazgaon, but due to the pandemic, it is not possible to hold physically. And this is the first virtual inaugural study circle meeting of this year. And I thank everybody for to be in this meeting. And I thank the members and the participants for attending this study circle meeting. And I hope that members and the participants will find this meeting very educative and informative in the presence of Honorable Sir and when the Vikram Sir is with us. Thank you very much. I hand over charge to the President, Mr. Raj.
Thank you, Janak bhai.
Yes, Raj.
Now I request Joint Convener of Law and Representation Committee, Parth Badeka, to introduce Justice also.
Good morning, one and all. I welcome Justice Sri Ujjwal Bhuyan. It is indeed a pleasure to introduce such a luminary. Justice Bhuyan was born on 2nd August 1964 in Guwahati. His father, Suchendra Nath Bhuyan, was a senior advocate and a former Advocate General of Assam. Justice Bhuyan did his schooling in Don Bosco High School, Guwahati, and thereafter studied in Cotton College, Guwahati. After graduating in arts from Kirorimal College, Delhi, he obtained his LLB degree from Government Law College, Guwahati, and LLM from Guwahati University. He was enrolled on 20th March 1991 with the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. He had practiced before the principal seat of Guwahati High Court at Guwahati and appeared before the Agartala, Shillong, Kohima, Itanagar benches of the Guwahati High Court. He has also practiced before the Central Administrative Tribunal, Guwahati. He has appeared before Labour Court, Guwahati, various civil courts, and State Forum, Arunachal Pradesh. He was the Standing Counsel of Income Tax Department for 16 long years, starting as a junior standing counsel in May 1995 and subsequently appointed as a senior standing counsel of Income Tax Department on 3rd December 2008. He was the additional government advocate, Meghalaya, in the principal seat of Guwahati High Court from April 2002 up to October 2006. He was engaged as the special counsel of the Forest Department, Government of Arunachal Pradesh from December 2005 to April 2009. He was appointed as a standing counsel of Guwahati High Court on 3rd March 2010. He was designated as senior advocate by the Guwahati High Court on 6th September 2010. He was appointed as the additional Advocate General of Assam on 21st July 2011. He was a member of Guwahati High Court Bar Association, Lawyers Association, Guwahati, Bar Association of India, All India Federation of Tax Practitioners, and Indian Law Institute, Assam chapter. He was appointed as the additional judge of Guwahati High Court on 17th October 2011 and confirmed on 20th March 2013. He was also the executive chairman of Mizoram State Legal Services Authority. Justice Bhuyan was closely associated with the Judicial Academy, Assam, and National Law University. Justice Bhuyan was transferred to the Bombay High Court and he took oath as a judge of Bombay High Court on 3rd October 2019. With this, I heartily welcome Justice Bhuyan and thank him for attending this inaugural study circle. Thank you.
Thank you, Parth. Thank you, sir, for gracing today's occasion. Now I request Parth Badeka to introduce today's speaker, Senior Advocate Vikram Nankani.
I welcome our speaker, Sri Vikram Nankani. Just like Raj said that this is a fanboy moment for Raj, it is a fanboy moment for us too. I in fact have the pleasure of listening to him so many times in the benches. So with this, I start his introduction. Vikram Nankani is a designated senior advocate. He is an India qualified lawyer at the bar since 1986 and has completed LLM from Government Law College, Mumbai in 1988. Vikram Nankani joined the chamber of Mr. Ashok Desai, senior advocate and former Attorney General of India between 1986 and 2003. Vikram Nankani sir has appeared as a counsel in various matters concerning commercial dispute, corporate matters, economic offences and criminal cases, tax, shipping and arbitration. He is a fellow of Chartered Institute of Arbitrators, London. uh, Mr. Vikram Nankani was a partner of ELP from 2003 until his designation as a senior advocate in September 2014. Vikram Nankani sir is also the chairperson of SIAC, India National Committee. Nankani sir has been acknowledged by Legal 500 as a leading individual practitioner in dispute resolution and litigation in India. He also regularly appears before various High Courts and Supreme Court of India and has to his credit several landmark judgments rendered by the courts that have been reported by various authoritative journals and reporters. Vikram Nankani has been also invited as an expert lawyer on various occasions, including in Singapore court and arbitration proceedings. Nankani sir has also been appointed arbitrator and has appeared before arbitration tribunal, both ad hoc and institutional in India and internationally. With this, I heartily welcome our speaker today, Vikram Nankani, senior advocate. Thank you, sir, for gracing this occasion.
Thank you.
Thank you, Parth. Thank you, sir, for accepting our occasion, for speaking on today's occasion. I request now Justice Ujjwal Goyan to address our members and bless them with your wisdom, sir.
Thank you, President, Mr. Shah, and good morning, friends. I'm very happy to be part of today's deliberation organized by the Study Circle of GST Practitioners Association of Maharashtra. Association has invited renowned senior counsel, Mr. Nankani, to talk on the recent judgment of the Supreme Court in the case of State of West Bengal versus Calcutta Club Limited and other connected cases, including the case of Ranchi Club, all reported in 2019 SCC Online. And in that context also to speak on taxability of trusts under the GST. I will not go into the details, Mr. Nankani will speak. But I must compliment the association and its office bearers for organizing this study circle and on a very interesting and a relevant topic, particularly in the state of Maharashtra. I have always maintained that for legal professionals and by extension tax practitioners, it is a case of continuous legal education. There is no full stop in the learning of law. As legal professionals, tax practitioners, we must keep ourselves updated by discussing about the recent trends in law and the interpretations given thereto by the courts. Only then we can be in a position to offer proper assistance to our clients, to the litigants, and thereby help in the administration of justice. Like medical practitioners who regularly organizes continuing medical education, they call it CME. Legal practitioners should also organize continuing legal education, CLE programs. And I'm very happy that GST Practitioners Association of Maharashtra, a leading association here, is not only doing that, but is also playing a leading role, at least in the field of indirect taxation. So thank you very much for organizing this event. Well, the subject of today's talk by Mr. Nankani, the West Bengal Taxation Tribunal had allowed the appeal filed by the Calcutta Club Limited, holding that it was not liable for payment of sales tax while providing food and beverages to its members. When this was challenged before the High Court of Calcutta by the state of West Bengal, the writ petition was dismissed and the view expressed by the tribunal was affirmed. SLP filed by the state before the Supreme Court, it was admitted, and on admission, the civil appeal was referred by a two-judge bench to a larger bench to consider three questions. The questions were whether the doctrine of mutuality would be still applicable to incorporated clubs or any club after the 46th Amendment to the Constitution, whereby Article 366(29) capital A was inserted. The second question was whether the judgments in Young Men's Indian Association and the two later judgments in Cosmopolitan Club and Fateh Maidan still held the field after this amendment, and whether the later two judgments which had remanded the matter back to the tribunal by applying the doctrine of mutuality post the above constitutional amendment could be treated as stating the correct principle of law. That was the second question. The third question was whether the 42nd Amendment had created a dimming fiction whereby provision of food and beverages by the incorporated clubs to its permanent members constituted sale, thereby holding the same to be liable to payment of sales tax. These were the three questions. Now, thereafter, a number of SLPs were filed on conversion. Those became civil appeals. And the issues were identical to the one in Calcutta Club. The second set of appeals related to the services provided by members clubs to its members, on which service tax was levied. The related writ petition was allowed by the Jharkhand High Court by holding that rendering of service by the Ranchi Club to its members was not a taxable service under the Finance Act 1994. Now, when this matter came up before the larger bench comprising of three honorable judges of the Supreme Court, the larger bench held as follows. Number one, the doctrine of mutuality continues to apply and applicable to incorporated as well as unincorporated members clubs after the 46th Amendment, whereby Article 366(29)A was added to the Constitution of India. It was held that the Young Men's Indian Association and the other two judgments which had applied the above doctrine of mutuality continued to hold the field even after the 46th Amendment. Thirdly, it was held that Clause F of Article 366(29)A has no application to members' claims. Insofar the second batch of appeals were concerned, Supreme Court held that from 2005 onwards, the Finance Act of 1994, whereby the service tax was introduced, does not purport to levy service tax on members' clubs in the incorporated form. Well, I don't want to go into the details of this. The association has picked up this topic for deliberation today, and how this judgment can be understood, interpreted, read in the context of taxability of trust under the GST regime. We have Mr. Nankani, a renowned counsel, to address us. So I would not like to stand in between. We like to hear him in detail. But only one thing I find from the agenda, today's agenda, that after Nankani speaks, there is 15 minutes slot by the chief guest. I feel that instead of chief guest saying something, it would be better if we can have an interactive session after Mr. Nankani speaks, so that the members who have their queries, the speaker can answer, and I may also have some queries which I would like to ask Mr. Nankani. So with this, thank you very much, all the members and office bearers of the GST Practitioners Association Maharashtra, and over to you, Mr. Nankani.
Thank you, Your Lordship. Thank you for laying the backdrop of a very, very interesting topic, made very, very lively by the Supreme Court's recent decision in October 2019. Exactly 156 years ago, before the Supreme Court judgment, Abraham Lincoln, in his famous speech on Gettysburg to the army upon the end of the Civil War, said that we are going to look forward to a government of the people, by the people, and for the people. I'm sure Mr. Abraham Lincoln did not know that these famous words would be converted into a concept of mutuality of interest and become a gateway for non-payment of taxes. He certainly didn't have that in mind. But yet today, mutuality is a concept which is built on the same foundation, the same edifice, that it is of the members, by the members, and for the members. With that, let's analyze how this whole concept has evolved and got woven into the law of taxation. Something which we otherwise thought was confined to what was known as the law of trust, which we know that under the Trust Act, there is really no definition of a trust except to say that this is an obligation, because a trust as such is not a legally incorporated entity. It's an obligation where the settlor has set up a trust and vested the powers to administer the corpus of the trust with a trustee for the benefit of somebody else. It could be the settlor himself or a third party. With that very clear concept of trust and a well-defined concept of trust, we now have that trust concept being extended to agency and also to mutuality and a panacea for many taxpayers in not to pay the tax. But is that the end of the road, or is this the final word on the subject? Is there scope for more debate or deliberation? We will come to it at the end of the discussion today. I'm sorry, I'm a little technically challenged. I mean, little is an understatement, largely technically challenged. I will not be able to share the slide and the screens myself, so I will need some assistance, and I'm sure the organizers would have somebody there to help me. So could we move on to the next slide? So the first judgment, which seems to have really taken this concept of mutuality into the rooms of a club, was an English decision which has been referred to in the judgment itself, which is Graff versus Evans. That's the next slide, if we move on to the next slide. And let's understand from where it started and how it has evolved. It's a decision rendered by the Queen's Bench Division in 1882. Sorry, could we move on to the next slide? I'm not sure whether I'm audible to the person handling the screen, sharing the screen.
Yes, sir. Yes, sir.
Yeah, thank you. Is that Sejal? Yeah. Okay. Now, this judgment had nothing to do with tax. Graff versus Evans was a case where you needed a liquor license if you were engaged in retail sale of liquor. Mind you, it was a retail sale of liquor. And Mr. Graff was a general manager of this famous club in England, which exists even today, the Grosvenor Club. And the argument was that if you were selling liquor to a member, then you needed a license. Sorry, it would be the next slide again after the contents. Yes, one more. Yeah. So, on the previous slide, I hope the person controlling the slide is hearing me so that he could synchronize. Yeah. He or she.
Yes, sir.
Sorry.
Yes, sir. I
Yeah,
can hear you.
Sejal.
Yes.
I'm sorry. Yeah.
Yeah.
I'm
Yes,
sorry.
sir.
So the question was whether you needed a license to sell liquor to your own member, and there the court brought in the concept of mutuality of interest and said that members of a club are joint owners of the property of the trust, and the club acts as a trustee for and on behalf of its members. So please see the concepts which are coming in: joint ownership, trustee. The club is a trustee and acts as an agent of its members. And therefore, when a trust is buying liquor from outside and selling it to its members, it is really not carrying out a transaction of retail sale, was the conclusion in that judgment. And since it was not a retail sale by the club to its members on the basis of the doctrine of mutuality, the club did not need a license in that behalf. The same ratio was then followed in 1940, where in the Trebanog Working Men's Club, the same issue was taken forward, and the concept of agency relationship was introduced and said that a club is nothing else but a agent conducting business collectively. So it's a collective body of different persons who jointly own the property, and that is why the distinction between the club and its members was obliterated. In other words, there were no two persons, because that is the fundamental basis for taxation, whether it is sales tax or VAT, or whether it is service tax. You need a minimum of two people. Not suggesting that there are elements of conspiracy in it, but otherwise in a tax you need two people. One is a seller, the other is the buyer. Similarly, one is a service provider and a recipient. So what we realize from these two judgments, Graf and Trebanog, is that the identity between the club, even if it was a separate legal entity, and its members collapsed. And they said there is really no distinction, or a distinction without a difference, between the club and its members. Can we move on to the next one, please? So the germs or the seeds which resulted in today what the law is in Calcutta Club are not in a tax law. They were in a law which was completely alien to tax. It was a regulatory provision dealing with the licensing of liquor, and from there it has expanded and evolved into a taxing principle. Can we go to the next slide, please, Sejal?
Is
Yeah.
not
Thereafter, we see how further it has been imported into India, and how this doctrine has come to be applied in India. We first had a judgment in the case of, and the slide will put it up there. No, just the one before this, please, Sejal.
yes.
There was a judgment, three-judge decision of the Supreme Court in Enfield's Canteen Club officers. And interestingly, the author of that judgment was Justice J.C. Shah, who also went on to write a concurring decision in the six-judge decision. Sorry, we have to go in the previous slide, not go above this. Sejal, could you? Immediately after Graf and Evans, I think you've jumped 2 slides.
Just a second, sir.
It says key Indian decisions
Yeah,
prior to
yes,
the
sir.
46th Amendment. Now,
Yes, sir.
there were, one more before this. No. You're going down. You're going down. You have to go up. You have to go up. You're going further down. Sorry.
Yes, sir.
Okay,
This
I'll
one, yeah.
abandon.
This one, sir.
Let
The key Indian
yeah,
decision.
no, just one before that. Just one before that. Sorry for the inconvenience. So how this no, I think don't worry. I think I'll manage it, because you're going down instead of going up. You go to Graf and Evans and then go to the very next slide after that. Now, the way this doctrine came to be imported into India was for the first time tested in the Supreme Court decision in Enfield, India Limited, which was in 1968. And the three judges, as I said, one of them, the lead judgment or the author of the judgment was Justice J.C. Shah. And Justice Shah wrote the concept there saying that the English judgments are not applicable because they were in a completely different context. And I think he picked up that nuance and therefore held that as far as India is concerned, the concept is very clear. Taxation will be applicable because there are two different persons, two different identities. Yes, that's a slide. And approved the decisions of the Madhya Pradesh High Court and the Mysore High Court in Enfield, India, which was a judgment in 1968. So the English cases were completely done away with. They said that they do not apply to the taxation field, and therefore now people thought that the law came to be settled of creating that distinction between the members and a club or an association. And this three-judge decision thereafter came to be tested in a six-judge decision, which became the edifice of the today's judgment in Calcutta Club, and that is the Young Indian Men's Association, which is the next slide, please. I'll come back to Madras Gymkhana. Okay, this was in sequence, so let's stay with it. Sorry, I'll move on to that. After Enfield, interestingly, the issue cropped up indirectly again in India in the context of Industrial Disputes Act. And the question there was whether a club was an industry. Now, why am I digressing from tax into industrial law? Because the tests which were adopted or the factors that were considered by the club, by the court, were the same which would be applicable also to tax. So whether profit is a motive or not, whether you were rendering services to your members under a Section 25 company, and whether those profits were plowed back into the company because that's what Section 25 of the Companies Act said. What was your relationship with the various members? And it is in that context that in Madras Gymkhana Employees Union, where the dispute arose about payment of bonus, and bonus would be paid by an industry, and an industry definition would not, if it did not include a club, the club was not liable to pay bonus under the Industrial Disputes Act. So again, a very, very different texture, a very different context in which the issue cropped up. And in Madras Gymkhana's case in 1968, the Supreme Court held that looking at the category of members, we hold that the relationship between the members and the club is that of an agent, and therefore the members were no different from the club. The club was not running an industry. An industry, therefore, would, since it was not an industry, it was not liable to pay bonus. What I have put up on the slides, and you will mark there, is that it was brought to the notice of the Supreme Court that there are different categories of members. Some members paid entrance fees. They also paid subscription. Non-members were allowed inside the club. Guests were allowed, but the court held all these factors to be irrelevant. The court held that the club exists for the members, and services to the members are for the pleasure and amusement of the members themselves. The mere fact that guests were allowed did not mean that the relation between the club and its members was any different. They said that members could only bring in non-members, entry was limited, and all these factors therefore were discounted. The argument further canvassed was that a club is a permanent entity. Members keep coming, going. New members join in, some members pass away. And the court held that yes, it is a permanent permanent character in that sense, a permanent nature, but that did not change the characteristic of a relationship. So every conceivable argument was canvassed before the Supreme Court. And mind you, this was a labor law, where normally the tendency of the court is to say that this is a welfare legislation, and a very broad, robust meaning should be given to the legislation. Setting aside all those factors and arguments, the court held that it was not an industry. The same decision, the same ratio was followed next year in 1969 in the Cricket Club of India case, where again the emphasis was that the argument was it's a separate legal entity. It is incorporated under the Companies Act, and the Supreme Court held that rather, in fact, the argument that is incorporated into the Companies Act strengthens the case of the club, because then the club is only the objective of the club is to serve the members, and the profits were not to be distributed as dividends; they were to be plowed back. And in Cricket Club, the ratio in Madras Gymkhana's case was reaffirmed. So, what's the scenario? The scenario is that in England, there is one view which is prevailing, and that view was not in the context of tax, it was in the context of regulatory legislation. That view, when it got imported into India in 1968, in the case of Enfield, was held not to apply to tax laws. After that, in case of Madras Gymkhana, in case of labor law or industrial law, in two cases it was held that the concept of mutuality did exist in India, and one could recognize that concept of mutuality. Now, with this background, we look at the case which turned the tables as far as the taxation things regime is concerned, and that is the next slide, which is the case of Young Men in India's Association in 1970. I am not sure what prompted the court to refer this matter to 6 judges. Sorry, the slide says 5, it's actually 6. My apologies. Because there is really no reference as to who doubted the validity or the correctness of the decision in Enfield, India. Be that as it may, the court was called upon to consider this in the context of the Madras Sales Tax Act as it then was in force. It dealt with 3 types of cases. Sorry, again there's a typo. It's a section 26 company of the 2013 Act, which then got 25 in the 56 Act. The second was assessee, which was a society under the Societies Registration Act, and the third was a trust. Ignoring the legal form of each of these assessees, one, as I said, was a company limited by shares, the other was a society registered in the Societies Registration Act, and the third was a trust. Ignoring the legal structure or the form of these assessees, the Supreme Court held that the English judgments in Graf versus Ivan and Trebanog did apply in tax matters, and in that sense, it took a different view from Enfield. Mind you, Young Men Indian Association does not say that Enfield India is overruled. He rather seeks to distinguish it, whether one can call it by overruling by implication, because there is such a principle acceptable in law. But having gone so far to say that the English cases are applicable, the court did not cover that last extra mile to say we overrule Enfield India, or we say that Enfield India is no longer good law. And the most interesting aspect of this judgment is that Justice J.C. Shah, who's the author of Enfield, is a party to this decision, gives a concurring decision where he seems to now take a different view on the position in English law vis-a-vis the Indian law. And ultimately, the test which the court says that ignore the form, the legal form, that apply the test whether the person concerned has a relationship of an agent with the others or is a trustee of the members. And they said that because the members are considered to be the joint owners, even if you sell something from to one member, it is actually reducing the share of the other member. So this was now the basis on which the law could have further evolved. 2 occasions arose before the Supreme Court, one in 1998, I think, and the other in 2008. But in both those cases, the Supreme Court remitted the cases back, setting aside the High Court orders to say the assessing authority, the fact-finding authority must render a decision on the nature of the relationship. And although the High Court in both those cases had held that the tax was leviable, both arising out of a sales tax, one Andhra Pradesh, the other Madras, the Supreme Court remanded the matters back to the High Courts. What happened to those cases thereafter? I've not been able to find. I wanted to see what really happened to the Supreme Court judgment, post the remand by the Supreme Court, what happened to those, but unfortunately that does not seem to be in public domain. Can we move on to the next slide, please? Then comes the interesting introduction of Article 366(29)A in the 46th Amendment in 1982. But before that, it had a kind of a roller coaster ride. The 61st Law Commission report was against such an amendment. And the Law Commission said that one doesn't need to bring in this concept because the mutuality principle does exist and must be recognized in Indian law. Obviously, the state governments were bleeding and suffering very heavily. And somewhere the state governments also wanted to overcome the big macro level issue which was raised by Gannon Dunkerley in 1958, dealing with indivisible contracts, or what we now popularly know them as works contract. So a comprehensive amendment was sought to be made to the definition of tax on sale or purchase of goods, and a deeming provision was introduced in the form of 6 clauses under Article 366. We are today really concerned with E because Clause F has been held not to apply to a situation that we are dealing with in the topic today, which is mutuality of interest. So whether AE would apply or not apply was the moot point before the Supreme Court in Calcutta Club's case. And what the Supreme Court picked up were the words in Clause E, which read as any unincorporated association or body of persons. Now, this has resulted in a very, very anomalous kind of a situation, where on one hand, in Young Men's Association, the Supreme Court said, ignore the form, even if it is set up as a company, even if it is a society registered under a law, even if it is a trust, ignore the form, look at the relationship. Now you have the constitutional 46th Amendment saying that this will apply to any unincorporated association of body of person. Did the draftsman really goof up? Did he make a big error of judgment, or did he take certain things for granted? I believe it is the last case. The last case seems to be that it was taken for granted that as far as incorporated associations are concerned, or persons as generally defined in the General Clauses Act are concerned, they would in any case be the subject of taxation because they are two distinct entities, forgetting what Young Men's Association did. So, consciously or by way of an aberration, these words have been used in Article 366(29)A, that is, any unincorporated association or body of persons. Now, in these cases, if there's a supply of goods for cash or for deferred payment or any other valuable consideration, then it is a deemed sale. Meaning thereby that we today have a situation where the Supreme Court judgment in Calcutta Club, if it is to be read in the context of 366(29)A, then pre the GST, we'll come to GST because the ball game changes when it comes to GST. But pre GST, we would have a situation where in the context of an unincorporated association or body of persons, it would be a case of deemed sale or supply. But in the case of an incorporated association of body, the Supreme Court at least expressly now holds in Calcutta Club that it is not a taxable transaction. I'm using the neutral expression taxable transaction because Calcutta Club touches upon both VAT as well as service tax, because the underlying principle according to the Supreme Court is the same. In both those transactions, you need two persons. You need, as I said at the beginning, buyer and a seller, service provider and a service recipient. That, therefore, the Supreme Court says is applicable to both VAT as well as service tax. But it doesn't really say, go to the extent of expressly saying that our decision will not apply to an unincorporated association or body of persons. Sub silentio, the ratio would be that Article 366(29)(a), which was not challenged in the Calcutta Club case, would continue to hold the field, and a literal meaning, the golden rule of applying the literal meaning, would be there. So, which that is why I said it is anomalous that today, at the foot of the accounts, as we say, the popular expression that is used, an unincorporated association or body of person would be liable, but an incorporated association or body of persons would not be liable, is one way of looking at the Calcutta Club, and that is a problem which would arise. Of course, one would, if one was appearing for such an assessee who is an unincorporated association or body of persons, one would still say no, as long as the concept of trust or agency or mutuality exists. It doesn't really matter what the form is, whether it is unincorporated or whether it's a body of person. If the legal test is not passed, then you would still not levy the tax. But as I said, this is sub silentio. Now, why I say that this anomalous situation will really create more and more problems is when you look at the statement of objects and reasons at the end of the same slide. It says in the which introduced Article 366(29)(a), it says similarly, while sale by a registered club or other association of persons, the club or association having corporate status to its member is taxable, sales by an unincorporated club or association of persons to its member is not taxable, as such club or association in law has no separate existence from that of the members. So please see, this is the root cause of the problem, the root cause of the anomalous situation. The draftsman of Article 366(29)(a) in the statement of objects and reasons forgot about Young Men's Association. It forgot that the Supreme Court in that judgment said, forget the form, it's only the substance of the relationship which is important. And that is why the statement of objects and reasons proceeds on an assumption that we don't have to worry about incorporated bodies or persons because they are in any way taxable. That's a very fallacious assumption made while piloting the bill on the amendment to the Constitution in introducing 366(29)(a). And this error of assumption has been carried forward, and as a result of which we have a situation where the Calcutta Club judgment says we are saying only in the context of incorporated persons or body of entities that they would not be liable for the tax. So this is the root of the problem. Maybe go to the next slide, please. Now, what were the facts which were sort of undisputed in a sense before the Supreme Court in Calcutta Club? That it is an incorporated entity. It was incorporated under the Companies Act. Then the club was treated as an agent of permanent members because that's the language used. I don't know whether there is any other category of members there, but I'm sure that the fact that they are using permanent members is that terminology means that there would be other category of members, and the judgment does not now distinguish between the treatment vis-a-vis non-permanent members. But remember, Madras Gymkhana did deal with all categories of members, including non-permanent members, including service members, including army and other services, garrison members as they call them in that judgment. Then the third factor was the tribunal as well as the High Court held this, that there was no consideration for supply of food or drinks. It's only a reimbursement of the amount. The purchase itself from the market is as an agent of the members. tax paid on sales to non-members and guests. This is extremely important. So it was never a dispute before the Supreme Court whether the sales made to non-members and guests, whether they could be also regarded as non-taxable transactions because they happen within the four corners of the club. Geographically, it's within in the precincts of the club that those members, non-members, and guests are served. This takes it away from the Madras Gymkhana, because in examining whether there was the club was an industry or not, the Supreme Court discounted the factor whether there were non-members who were allowed entry and those non-members were served. It said that doesn't matter. Even if those were regarded as sales to non-members, it still did not make it an industry. But sorry, in case of Calcutta Club, this was never a dispute before the Supreme Court. So when we are looking at the ratio and we are trying to understand the ratio, we have to keep this factor in mind, that the ratio of the Supreme Court judgment would not apply to any supply. And I'm using the word supply because that's the new term that we have been asked to learn in the context of GST, to non-members and guests. Can we go to the next slide, please? So a two-member bench of the Supreme Court made a reference to a larger bench, to a constitution bench, and they formulated the points of reference, which my Lord Justice Buyan has articulated. So I am not going to take time on this. I'll go to the next slide. So with these questions which were there, which included the validity of Young Men's case, whether it continues to hold the field, and the two other cases of Cosmopolitan Club and Fateh Maidan Club, both of which, as I said, they were remanded back, and then what happened to them, one doesn't know. Can we move on to the next slide? And what the Supreme Court holds, that the statement of objects and reasons which I've read out above indicates only unincorporated clubs or associations are covered under Article 366(29)(a). Hence, incorporated clubs or associations are not hit. 61st Law Commission concluded that there was no need to amend the Constitution for taxing members' club. Statement of objects and reasons has misunderstood Young Men's case and has wrongly assumed that the sale of goods by the club in the corporate form are already taxable. And Enfield India's decision has been expressly distinguished in Young Men's case as far as the sales tax is concerned. I'll come to the service tax in the later part, maybe 2 slides away. Can we please move on to the next slide? The Supreme Court also holds that the definition of the person under the General Clauses Act includes association, whether incorporated or not. However, Clause 29A uses the words body of persons. So what, in other words, the Supreme Court says that don't look at the definition in General Clauses Act. Don't look at the definition in the General Clauses Act. That definition will not apply here because the Supreme Court has departed from the General Clauses Act. It has used the words unincorporated clubs, unincorporated associations or body of persons. And then, of course, it holds that subclause F of 366(29)(a) doesn't apply in the context of supply of food or drinks by the club or association to its members. And it says that valuable consideration needs two persons, promisor and a promisee, as held by Young Men's Association. There cannot be a sale to oneself, is what the Supreme Court has concluded. Mind you, Calcutta Club is 3-judge. Young Men's was a 6-judge decision. It has followed it. Had it taken a different view, it could have done so on 2 accounts. Number one, the legal provisions have changed. There are a lot of new provisions introduced into the law, and or referred it to a bench larger than the 6 judges, but it chose not to do so. And relying on Graf versus Evans, tracing the history to the doctrine of mutuality therein, and extended in Young Men's, it continues to hold the field, is the ratio of the Supreme Court in Calcutta Club. Maybe move on to the next slide, please. what you can summarize is of the ratio is stated in paragraphs 37 to 44, and I have tried to capture it in 3 bullets. And it says whether doctrine of mutuality applies after the 46th Amendment. Answer is yes. Is it applicable to both incorporated and unincorporated clubs? Seems to be the decision that this doctrine applies to both. Now, if the doctrine applies to both, whether the legal fiction has been taken away by the 46th Amendment is, as I said, the conclusion with respect to unincorporated clubs is unsupported by any reasons. It could be said sub silentio. In fact, appears to be contradictory to the analysis. So when it analyzes 36629A, it says 36629A only touches upon unincorporated associations or body of persons. But when it comes to extending the doctrine of mutuality of interest, it says it is uniformly applicable to any such body of persons or associations. So there is a bit of an anomaly. It doesn't really head-on deal with the next question, and it begs the answer to the question that whether the Article 36629A has, by a legislative process, overtaken or overridden the concept of mutuality and would not apply to unincorporated clubs. It doesn't say it in so many clear words. Then the next question is whether the judgment of Supreme Court in Young Men's case still holds the field. And the answer is in the affirmative. Supreme Court said it does apply even after the 46th Amendment, and Clause E of Article 36629A has not done away with its ratio. And finally, it holds that subclause F of Article 36629A does not apply to members clubs, which applies to hotels and restaurants to overcome the 2 decisions in 1972, one of Associated Hotels and the other is of Northern India Caterers, which does not deal with the concept in that sense of mutuality, but whether there was sale or no sale, and that is how the legal fiction of sale was introduced in Clause F. Next slide. Can we go to the next slide, please, Seja? Yeah. Now let's talk of the service tax. Look at, please stay on with the previous slide. Look at the wide spectrum of the cases which decided across India. Jharkhand High Court dealt with this issue in Ranchi Club. Gujarat High Court dealt with this issue in Sports Club of Gujarat. And then, of course, there were certain tribunal decisions. The second of the tribunal decisions on the slide relates to a housing society, a cooperative housing society. Now, these issues, all of them rely, the common thread in all these cases is the reliance on Young Men's Association's case of the Supreme Court. And all of them relying on that said that the concept of mutuality also applies to service tax. Now, as we all know, service tax underwent a paradigm shift in 2012. Until 2012, it was a classification-based taxation. After 2012 came the negative list, whereby unless you fall into the negative list, you were regarded as a service provider and tax would be levied on everything. So it was in that sense a residual provision, something similar to the definition of service that we now have in the Constitution, which I will come to a little later. So the law prior to 2012 contained a definition in service tax. And that definition said club or association means any person, I've put that word in bold, person, or body of persons providing services, facilities, or advantages for a subscription or any other amount to its person, but does not include, and this is the twist in the tail, any body established or constituted by or under any law for the time being in force. Meaning thereby that the word person, which was in the main opening part of the definition, would refer only to unincorporated entities. Otherwise, the General Clauses Act and the definition of the word person would take within its meaning the incorporated entities also. But by this exclusion, it has now been clear that it would only cover unincorporated associations or body of persons. So this was in that sense aligned with Article 366(29)(a). Come to the position after 2012, which is on the next slide. Here we see that there is a definition of person, and the definition of person includes an association of persons or body of individuals, comma, whether incorporated or not. This phrase, whether incorporated or not, was specially introduced in 2012, and this is, mind you, in the definition of person. And there was a definition of service which read with the definition of the word person, you would see said means any activity carried out by a person for another for consideration and includes a declared service. Now, if I apply the definition of the word person, and if the person definition is wide enough to cover an incorporated entity, and if that incorporated entity carries out an activity for another, then in that case, for consideration, obviously, then in that case, it would be regarded as a service. Now, unfortunately, the Supreme Court went by the explanation 3, which said that for the purposes of this chapter A, an unincorporated association or a body of persons, as the case may be, and a member thereof shall be treated as a distinct person. Now, once again, please see the generosity of the draftsman who forgot to put in the word, to remove the words unincorporated and said incorporate, in fact extend it to incorporated. So the main part of the definition is wider than the explanation. Normally, the explanation is the one which gives a wider meaning to the main provision by covering certain areas which may have not been expressly provided in the main part, and therefore it seeks to explain the main part by widening the width of it. This is an explanation which, instead of widening the width of that main part, has sought to narrow it down, and the Supreme Court has latched onto it, if I may use that word. So the Supreme Court says that explanation 3A says that for the purposes of this chapter, only an unincorporated association and its members will be treated as a distinct person. In other words, the legal fiction which was created, and one remembers Lord Asquith's famous words, when he said that give the putative state of affairs the fullest possible meaning, but don't stretch it beyond its natural meaning. So here you are, the statute in black and white in the form of explanation 3A confines the legal fiction and treats the members as distinct persons from an association only in the case of an unincorporated association or body of persons. So Supreme Court therefore says that as far as the doctrine of mutuality is concerned, it may or may not, again as I said, it has left it unanswered in so many words, and this is one area which will, I'm sure, crop up again for discussions before the courts as to what did the Supreme Court say post 2012 in the context of service tax as to whether this explanation 3A renders transactions taxable when it is between an unincorporated association or body of persons and its members. I'm conscious that there are some exemption notifications which sort of bring down the gravity of the situation, but still there could be on a taxability issue, keeping the exemptions aside, because exemptions may not cover the entire gamut of cases which would fall within this definition, as to whether Calcutta Club extends the concept of mutuality also to unincorporated associations, notwithstanding explanation 3A, and again in the context of sales tax, notwithstanding Article 366(29)(a) clause E. May we move on to the next judgment? Next slide, please. Sorry, can we move on to the next slide?
The findings of the court
Yes, please. Yes.
after this.
That's fine. Yeah. No, I think the one before that was, I'm just trying to look at my slide. I think it's the one, finding of the court. Yeah.
Yes, sir.
So as I said, prior to 2012, one can understand, and perhaps in my view, the Calcutta Club decision would apply on all fours prior to 2012 in the context of service tax. It says doctrine of agency and trust and mutuality will extend because there are no two persons. The second part also will apply, said that incorporated clubs or associations are not covered under the service tax net prior to 2012. That seems to be very clear. What is not clear is post 2012. Now, unless and until one comes to the conclusion that the statute suffers from legislative incompetence, mind you, there are very few windows which are available or open to attack a plenary legislation by a parliament. Now, one of them would be legislative incompetence. And now, of course, after we have seen Navtej Johar's case, that even Article 14 can be used to strike down a legislative piece, which hitherto the courts were slow because Article 14 deals with arbitrariness, and to attribute arbitrariness to a parliament was not a very well accepted concept. But today, the new modern thinking, the new thinking after Navtej Johar's case is, and extended in Puttuswamy, that Article 14 is also available to strike down a parliamentary legislation. Now, so therefore, the moot point is that by introducing a definition of person and by introducing a definition of service, the mere fact that explanation 3A is restrictive in nature, whether it would also control the scope of the main provision or not, and whether by legal fiction the parliament has the competence to say that notwithstanding the doctrine of mutuality, I, the parliament, still say that the members and the association would be treated as two different or distinct entities. To my mind, uh, it depends on which side of the table you are. 6 is to 1, 9 is to the other, depends on how you read it. If you are for the SSC, you will say that this judgment, even though it's sub silentio, will apply also to a case of unincorporated or incorporated members after that. On the other hand, if you are for the revenue is likely to raise the point that if this provision was not challenged and absent a challenge to its legislative competence by legal fiction, the parliament has removed the distinction, or parliament has addressed the question of mutuality by saying that we, the parliament, will treat them as two distinct persons or two distinct entities. And therefore, the doctrine of trust, agency, and mutuality, all of which, mind you, all the three doctrines, whether it is trust, whether it is agency, whether it is mutuality, proceeds on the footing that there are no two individuals. It is the same pooling of resources by the members. So in a club, all of them pool resources together and defray the very expenses. In a society, housing society, everybody pools in the resources and manages the society, and the society is nothing but a collective name of its members. Each individual member, instead of engaging a security guard or a housekeeper or a other services, would now be using society as a platform, not as a separate legal entity, but as a platform for collectively doing what individually each one of them would have otherwise done. Can we go to the next slide? Sorry, Sejal, may I request you to go to the next slide, please?
Yes, sir. It's not the. It's a second. don't know what the issue is.
Yeah, this should be.
Yes.
Yeah, I've already. Can we go to the GST one? Yeah, I've already dealt with this
Okay. So the next one.
discussion on the next one, GST. Yes, after this, let's now see whether GST makes any changes, or would this judgment continue to hold the field even after GST. There is an overarching principle, and which I'm sure all of you know, which is based again on a House of Lords judgment in 1901, which is Quinn versus Latham, that a judgment is an authority for what it actually decides and not what logically flows from it. The Supreme Court obviously did not consider or have before it the provisions of GST. So let's look at some of the important provisions of GST which probably would have an impact on the ratio of Calcutta Club. The first is as Schedule 2. There's an entry in Schedule 2 of CGST which says that supply of goods by any unincorporated association or body of persons to a member thereof for cash, deferred payment, or valuable currency will be treated as a supply. So bodily lifting 36629AE and planting it in Schedule 2 of the CGST. Now this is again there in the statute book. Calcutta Club, as I said, in a way tries to use this to draw a distinction between incorporated and unincorporated, makes a categorical finding in case of incorporated, but extends the concept of mutuality to unincorporated without saying really whether they will be taxable or not because of Article 36629A. So it extends mutuality to unincorporated, but then stops short of saying what would be the tax treatment in case of unincorporated associations. The next change in GST is the definition of business. Now, if you see Section 2, subsection 17E, business now specifically covers within its ambit provision by a club, association, society, or any such body for a subscription or any other consideration of the facility or benefits for its members. Mind you, this is now a part of the definition of business. How this will pan out will be very clear. And again, mind you, Madras Gymkhana Cricket Club said a club or association is not an industry. Now look at Section 7, which talks about the scope of supply. This is, in a sense, read with 9, both put together, Section 9, would both be construed as charging provisions. And what Section 7 says while defining scope of supply is any supply, which is of course made, I have eliminated the other words of goods or services or both, in the course of or furtherance of business. So if you make a supply, and we all now know it's pretty elementary, that supply includes both sale, which is transfer of property in the goods, or rendering of a service. So if that is done in the course or furtherance of a business, and business includes a provision by a club or an association to of the facility or benefits of its members, then given the wider meaning, a larger meaning of the word business, would this transaction not be taxable under Section 9? In my submission, and it may sound very anti-assessee or unfriendly to the assessee, but it seems that until such time that this definition of business is tested in a court of law, until such time the court holds that this is either suffers from legislative incompetence or it is arbitrary and unreasonable under Article 14, or that the words of the facilities or benefits to its members have to be read down to mean that if there is mutuality, there is still no business which is conducted between the member and the club till such time the plain vanilla language used in the GST provisions stares at us and probably points out very strongly in favor of taxability of such transactions, notwithstanding the judgment in Calcutta Club. I hope I'm proved wrong one day, and that will be the day which will be a joy for many assessees. But as I read the section, I can't do disservice to myself and to all our fellow practitioners in giving it any other interpretation which I think would be not otherwise on first principles sustainable. Can we go to the next slide, please? Yes, the next slide merely talks about the exemption under GST. Exemption is again a prerogative of the government or the executive. So that says that it is unincorporated body or non-profit entities registered under any law for its time being enforced to its members by way of reimbursement of charges or share of contribution. So that's a matter of exemption. Whether taxability or not is a separate subject, which is the exemption. I've reproduced the provisions in the next slide. Sejal, can you kindly share that with our members? Finally, what really would be the questions which would arise, both for the past, that is pre-GST and post-GST, is that going forward, what can we do or prevent from not happening adversely to questions. So as I have said, I have already pointed out the next slide, please. This is the exemption, which of course doesn't really come in the way of taxation. Government has a prerogative to provide an exemption. Some may argue that when you look at the exemption, it may be used as an aid in the construction of a taxing statute, but that would be tail wagging the dog and not the dog wagging the tail. That may not be permissible, that you look at the exemption to see what was the original intent of a taxing legislation. Either you fall within it or you do not fall in it. The famous case of Govind Sharan and Ganga Sharan. Next slide, please. That is the questions which would arise. So the first is the anomalous consequence, the unintended consequences of an unincorporated and incorporated company entities. I've said a lot on it, and I think this is one of the questions which will come up, and many of us would be struggling to get an answer, even if you read Calcutta Club minutely and with a hair comb. What is the possibility of claiming refund for the past? We all know that refund is subject to unjust enrichment, and there are several other conditions attached, whether you have taken the credit or not taken the credit. But that again is one area of possible potential litigation which could crop up, with many trying to take advantage of the judgment in Calcutta Club. Then, as I said, I've already flagged the issue of what would happen when the court is faced with a definition of business in GST. Will it turn the tables? Will it give a different nuance to the whole law? What happens in case of non-members? And as I said, a judgment is only an authority for what it actually decides. And in the case of Calcutta Club, non-members was never an issue, and on non-member transactions tax was being paid. So today, if today an even incorporated entity undertakes events where non-members are included at a charge or at a fee, it would be considered as a taxable transaction. Supply of material at a cost to members and non-members, again the same distinction will have to be remembered, that as far as non-members are concerned, that would be a taxable transaction. As far as supply to members is concerned, if we are able to prove that it is only reimbursement of charges and that it was not intended to do anything more than just help the members and assist the members, so you were acting for the members and for the benefit of the members, and you were only collecting a charge for reimbursement, then of course Calcutta Club ratio would apply. The next slide, please. And perhaps this is the last slide that I have. My takeaway. Sorry, that's a bit of a teaser, because in today's lockdown, you can't go to a restaurant. It's only a takeaway. So pre-GST, no VAT, sales tax, and no service tax on incorporated entities if the transaction with to its members is based on principles of mutuality, agency, and trust, and transfer of property or service rendered is not for consideration, which does not include reimbursement of charges and and which includes reimbursement of charges of or contribution. Transactions with non-members are taxable. This is the pre-GST. One would say the best ratio which flows from Calcutta Club. Post-GST, the issue needs to be revisited. Legislative competence has to be, the test has to be applied. Articles 14, the legal fiction definition of business consideration. Consideration was also not defined under the Service Tax Act. So this is a new definition of consideration in the GST Act. Under the old service tax law, there was in the evaluation rules and section 67 a definition of gross amount, but not directly of consideration. And a new definition of service has now been introduced in Article 366(29)(a), which says anything other than goods. So how do you now harmonize and reconcile the various definitions, including the new ones which are introduced? The word supply itself is very wide. It's wider than what it was earlier, the word definition of business. So as they say never again. And probably you will see one more avatar, one more round on mutuality being discussed and thrashed out in the Supreme Court in the context of GST. And therefore they say you are always going to be a learner. There is never an end to these kind of discussions. There is no yet the last word on the subject. It really reminds me of what one of the judges, and if I may quote him, because I was personally present in court, was a case where once in a matter, Justice Variawa was hearing a counsel saying that the law has been laid down for the last 30 years and there are judgments and judgments on the same topic, the ratio of which has been consistently followed. This is a time-tested ratio, and this, my lord, is the last word on the subject, and he handed over a judgment. And Justice Variawa read that judgment and looked back at the counsel and said, the last word is yet to be known to you. So never say never again. We will have probably one more round of Calcutta Club, and that would be a new avatar, which probably will either reinforce the law or destroy the edifice and rebuild it all over again. Thank you very much all for being very patient, and thank you, Justice Buyan has been a constant source of inspiration. Thank you, Raj and Parth, for the undeserved comments that you made. Thank you, one and all. Thank you, Nikita Ben, for inviting me and making me a part of this webinar.
Thank you, Vikram, sir. Now, sir, you would be comfortable taking questions?
Yeah, I'm fine. I think Justice Buyan said that we must have an interactive session. Though I would have...
interactive session, yes, certainly yes. We should have an interactive. We have a lot of young minds. They may have queries. They should come forward.
Thank you, sir. With regards to the instructions to the members, whosoever wants to ask the question, they may raise the hand or they may type in the chat box, and then Sejal madam would take it over. We have one or two questions already. Madam, Sejal madam, can you please take those?
Yes. Yes, with your permission, sir.
Yes.
Yeah, please go ahead.
Yes. So what is the body of person where it has been defined in any act? In income tax, it is BOI. How about BOI is different as BOP?
So, except for income tax, I don't think there is any other law to my mind which has defined this expression body of persons.
Okay. Thank you, sir. So then the next is, if the doctrine of mutuality still exists, then why GST is being levied on housing society, as they are only servicing themselves by procuring the services or goods from third party, whether it can be challenged on the grounds which we are discussing today.
So, as I said, the 9 yards of this magical words, mutuality of interest, has been now understood to have its traces even at the stage of acquisition. So, in other words, if a club or an association or a society acquires goods from third parties and for the benefit of its members, it either distributes them or uses them, then the courts have held that the very acquisition by the society in the name of the society or by the club in the name of the club is as an agent of its members. Now, when you bring in the concept of agency and principle, then you really are saying that this is one and the same person that you're dealing with, and it is not, and there are no two separate entities involved in this kind of a transaction. In the context of society, therefore, one will have to see how it is contractually dealt with. Obviously, when a society acquires goods, it is paying GST to somebody else. Paying GST to the third party from which it acquires is a different situation altogether from paying output tax.
I think that was really informative. Move on to the next question. Yes. Yes, Pa.
Yes. So if I may, sir, thank you for the great address. As you already said, sir, that under GST it is not like a settled case that whether principle of mutuality will completely apply or not will have to be tested. In the light of that, how would you say would the best approach be with regards? There are a plethora of ARs. The ARs in relation to a lot of these association, not young mans, but Lions Club and Rotary Club, they are dealing with several different aspects of the same association, and there are judgments. The ARs are slightly, I mean, most of them are going towards with the fact that they have to be registered and they have to pay tax. Some of them saying that if you are doing charitable activity and if you are just doing for the benefit of the member, then it is not one of that. So in that case, what do you think would be the right approach in this case, especially since though 217E actually defines business and it kind of prima facie does seem like it includes all the unincorporated and the incorporated aspects. But in the course of or furtherance of business, the point is even if the person or that concept can fall under business, whether that in the course of or furtherance of business is happening or not, that thing is still very significant.
Undoubtedly, I think, Parth, you're absolutely right that now in the new phase, when we have round 3 of the Calcutta Club scenario, I say round 3 because the first round I reckon is the young men's, the second is the Calcutta Club, and the third potential round whenever it happens. I think the whole case will turn on the definition of business. And if someone were to argue that although the words club and associations and other bodies have been specified in clause E in section 217, subsection 17, that by itself would not per se make them taxable. It will still have to be as part of the business. And if I am not, and if we go back to Graf versus Evans, if I was going to sell liquor to my member, and that sale was not regarded as business, because if it was business, then they would need a license. And if that sale was not regarded as a business, then notwithstanding this clause E, whether you would still tax the transaction under GST will be the moot question. Now, does it mean that somebody will have to challenge the constitutional validity of section 217E, or will it have to be read down to say that an associate, because again, the the definition of business doesn't stop at merely naming the entity of club or an association or a society. It goes further on to even define the end result of that transaction, namely for the benefit of its members. Now, in that situation, the question that will arise is the fine question, if I may say so, does the parliament have the competence to really legislate against the doctrine of mutuality? Because mind you, doctrine of mutuality otherwise is a doctrine based mainly on equity. If it was in the context of trusts, and trust is mainly a equitable law, and from there it has been imported across the board, as we have seen in cases of Licensing Act to Industrial Disputes Act to taxation. Now, the government, because taxation is so very important for the government and it forms an important part of its revenue, source of revenue. If the government or the parliament, as we know, has got all the powers that it has, if it is not excluded, and today we have, of course, Article 246A and even 248 has been made subject to 246A. In that scenario, can one say that the parliament now still has the residual power to legislate in respect of matters which are not covered by exclusively by Part 2? And if it has, and it has done so by obliterating this distinction or maintaining that distinction, sorry, not obliterating, my apologies, maintaining this distinction by a legislative mechanism, then in that sense the tax would be leviable and the doctrine of mutuality would not find place in GST. So but it will turn a lot on the definition of business. You're right.
I believe, Raj, can I say? I believe
Yeah,
what
yeah,
you say, Vikram, what you say is perfectly right, because that's what the battle is now going to go on in the direction. Incidentally, I just want to add, YMCA tribunal was argued by my senior, Mr. B.C. Joshi.
Oh,
So
okay. Oh, okay.
and it
Wow.
is such a beautiful judgment by our tribunal. It is arising from Bombay, Maharashtra.
Okay.
So it's a Bombay tribunal judgment which has gone directly to Supreme Court. That's
Oh,
what.
okay. Wonderful. Okay.
Thank you. Thank you.
Yeah. These are little historical gems which we don't realize, and we pick them up at seminars like this.
Yes.
madam, we have question.
Yes, can we take the next question now?
Yes.
Yes. Uh, so will the membership fees charged to members without supply of any services or goods be taxable under GST?
So, yes, now again, we may have to make that as a fine distinction. And I think these are all testing questions, because if there is a membership fee or a subscription which is paid by a member, whether that would amount to, in the way, rendering a service by the club to its members. Now, one could there maybe carve out an exception to say that if a membership fee is being collected, which is a membership fee for entry and not for rendering any other service or by retaining your status as a member, in that situation, it may be a stronger argument to say that it is not taxable. But again, coming back to the definition, that if it is a share of contribution, that's the expression used in the definition of business. And I think it has been very thoughtfully crafted to bring in and cover all possible angles of where all the payments are made in the context of a society or an association or a club. So it's not just for the benefit of its members, but also share of contribution, which is part of the definition of business. I think if you go back to the slide on the business part, you will find that there is that also in furtherance of its for facilities or benefits of its members. Sorry, this was the definition in the earlier part, but today it is for the benefit or facility. So one could maybe strongly argue that as far as membership fee is concerned, don't levy a tax on it. For other supply of food and drinks, there could probably be a element of tax.
Thank you for that, sir. So then we move to the next question, is regarding, so any surplus to the society will be against the concepts of mutuality and reimbursement?
No, surplus per se is not antithetical to the concept of mutuality, because as we know that even in section 25, which is also there in the new 2013 Act, and says that as long as the dividend is not, profits are not distributed as dividends, so the generation of profit is not per se antithetical to the concept of mutuality. It's just that you do not then distribute those profits. You plow them back, use them back for the benefit of all the members collectively, because they are joint owners in that sense.
Thank you for that. So then the next question is, what would be the time limit for claiming the refund and the period for which the refund can be applied for service tax and VAT? Now, in
I'm
this
sorry,
case,
I
what
couldn't
would
hear
be
the
the
last part.
yeah, okay. What would be the time limit for claiming the refund and the period for which refund can be applied for service tax and VAT?
So the period of limitation is the same as per the statute. Those who haven't applied, then the constitutional bench judgment in Mafatlal will go against them, because Mafatlal said that it is only when you strike down a provision to be ultra vires, and then the limitation in the act will not apply. Otherwise, those who have missed the bus, sorry, they have missed the bus. Those who have a refund application pending, subject to all other conditions, they can pursue that.
Okay. So then the next question is, what is the difference between the two intentions? The first one is agents of club or trust, and the second one is members and clubs are not different and same. Is there
Sorry,
any difference
you said
between the two?
you said what
Yeah,
is the difference between an agency and a trust?
Yeah, first one is agents of club or trust. The second one is members and clubs are not different and the same thing.
No, so please understand that yeah, they are all different legal concepts, but pointing out to the same situation, namely that the identity between the two is not distinct or different. So as I explained at the beginning, a trust is something which is an obligation which is imposed on by one person on another, namely the settlor on the trustee. And that is where you say that he is holding it for behalf of the beneficiaries of the trust. And that is where the trustee concept comes in. There is no separate legal entity. Similarly, in the case of an agent of a disclosed principal, it is actually the principal who himself is liable. I mean, I don't want to get into the finer aspects, but if you look at Section 230 of the Contract Act or similar provisions on agency in the Contract Act, if I am an agent of a disclosed principal, then really speaking, the agent is not liable. In that scenario, if the club is a collective name for all the members, and each member is therefore, in that sense, an owner of the club, then what the club is doing as an agent is actually the work which is being done by the principal, and the club itself would not have any liability of its own if we were to extend the principle of Section 230 of the Contract Act. It is in this scenario that you have then come up with a judge-made law on mutuality of interest. So that is where the roots go into the question of agency and trust. All this is not elaborated in the Calcutta Club. I'm just using the first principles of law as we understand, and then trying to understand that why they are applied to taxation, because of the criteria of minimum two persons, two distinct persons.
Okay. So then the next question is, considering the fact under Calcutta Club, in the absence of two persons, the question of consideration doesn't apply. Whether the same can be argued under GST despite inclusion in business definition.
But there is also a definition now of consideration, which is also very wide, which is applied. So, as I said, if you hold in a country like India that parliament is supreme, like in most common law countries, that the parliament is supreme. I mean, today, as I have often said, and you would probably heard this from me even in the past, it's a cliche that I often use, that parliament can tomorrow define a man to be called a woman and a woman to be called a man, or vice versa. It can say the law that tomorrow onwards black will not be black, it will be white. Then the only way you can set it aside is by showing that it suffers from legislative incompetence. Now, mutuality is the concept which is born in equity, and it is not a constitutional concept where you can say that this destroys the basic structure of the constitution. And a la Keshavananda Bharati, you then say, oh, you can't bring in such an amendment in the statute. So the parliament being supreme, that it is in India, you can always say that notwithstanding mutuality of the doctrine of mutuality, in this case, these two persons will be treated as distinct persons. Today, we have that in GST in different forms. If you look at it, and that's normally a test applied by the courts to understand the scheme of the act. In the context of registrations, in the context of input tax credit, there is a definition which says that notwithstanding the same legal entities, separate places of business will be regarded as distinct persons. So if that is not questioned by anybody so far, and if all of them have accepted that to their joy and merry making, that yes, separate places of business will be treated as separate registered persons and distinct persons, then why can't the parliament have the power to also import that distinction into treating transactions for taxability?
Okay, thank you, sir, for that. So then the next is a participant wants to know that they have a sports club in New Bombay. Now with a gym and a restaurant, everything is there and is taxable under GST. All its receipts from members on the grounds of facilities to members. So does GST imply on all these members' activities, the gym and the restaurant, and is taxable?
So, garbage in, garbage out. That's how we lawyers try to answer questions. This question should be the member concerned should either take it upon as a professional assignment and deal with it professionally and answer it on facts, or because otherwise, as I said, it's garbage in and garbage out. The only exception made here is that if it's a proprietary club, and when I say a proprietary club, it would be liable. Otherwise, it would not be liable. Is that where the shareholder is other than the member? So there are many today. We find there are many clubs in and around Mumbai and in and around the MMR region where people have set up clubs, whether for business purposes, whether for recreation, whether for sports, where the members are different from the shareholders, and the company takes in members on an annual basis or a certain fixed period, and they are also called clubs. So there is no magic in the word club just because you call yourself club. So one will have to look at the articles, the memorandum of association, the articles or the bylaws if it's a society, and then come to the conclusion. But mere use of the word club is not going to give you a definite answer.
There's the same connecting question relating to this clubs, that in GST, can we say that the provision is only made to deem that providing the facilities by clubs is business, but there is no deeming provision that it is a supply. Also touching the requirements, there should be two persons and consideration. Can we still change that in GST on the grounds of Calcutta club ruling that there are no two persons and consideration in case of provision of facility by club to the members?
So I'm sorry, but I do not fully understand the type of the question, because the word business is used in the definition of supply. So you don't need another extended definition of supply. If supply under section 7 takes within its sweep the word business, and the word business is then defined in the statute, it automatically means that the definition of business is set in or incorporated in section 7, which defines the scope of supply. So even for the purposes of supply definition, the same definition would apply.
Madam, Ishan Patkar has one query. Can you unmute him?
Yes.
Ishan.
Yeah, just a second. Let me unmute him. Yes, Ishan.
Hello.
Yeah,
Vikram
go
sir,
Ishan.
thanks for a very enlightening lecture, and thank your lordship also. Now, the question that I have is, there are actually a couple of interrelated questions. First is, Calcutta Club seems to be taking the view that even with respect to unincorporated associations, the 366(29)(a) clause E has failed to achieve the purpose for which it was enacted, inasmuch mutuality still continues to apply. Now that they have done on the basis of the word consideration by giving it the contract law meaning. Now there are so many judgments in which consideration has been given other meaning. For even in taxation, they say that an illegal transaction may not be a contract as per contract law, but it can still be taxed. Is it really required to give a contract law meaning to this word consideration? And secondly, has it ever happened earlier in the last 70 years that a constitution amendment has been declared redundant in this fashion? Because this clause was brought in for this very purpose, to negate mutuality. And by simply relying on a restricted meaning of consideration, the Supreme Court seems to have made it completely redundant.
So, Ishan, I must admire your courage. You said it in more direct and bold words. I was trying to be very polite by using the word sub silentio. So I agree with you that they have said that the concept of mutuality extends to 366(29)(a), but they have not said. Nobody has said that it is in any case bad law or is something which suffers from any kind of infirmity in the context of a plenary legislation. So though clause E does use the word consideration, and having held that the statement of objects and reasons does cover only unincorporated entities, I think they haven't gone that last extra mile to say that such transactions would not be taxable. They have commented on the word what consideration should be, but again come back and held that only incorporated entities would not be covered by the legal fiction of a deemed sale. So this is one gray area which is left unanswered in my view. And if then someone were to ask me personally, individually, I would think that this judgment is not an authority for the proposition that an unincorporated association or body of persons, when it undertakes a transaction or a supply of the kind mentioned in E, is not taxable. I would think it is.
Lordship, would you like to speak something, or we have last 10 minutes?
Yes. After the wonderful exposition of the law by Mr. Nankani, I don't think I need to add anything more. I must thank Mr. Nankani. You have taken us to the English principles, English judgments, up to Calcutta club decision. And when I was reading, as Mr. Nankani had pointed out, when I was reading Calcutta club judgment, in a way, I was also happy that finally maybe something has been settled. But now, after today's deliberation and going to the definitions given to business, consideration, and supply in the Central GST Act, well, as Mr. Nankani has rightly pointed out, it may once again be open for having a re-look at the entire what we thought was a final decision in the matter. So we look forward to that. I would not like to comment on this. It may come it may come to the court. Bombay High Court could be one of the platform from where this could go further. So I reserve my judgment, but Mr. Nankani has very rightly pointed out that what Calcutta High Court, Calcutta Club has said may not ultimately be the final word on this subject. So with this, I really thank you, Mr. Nankani. It's been a learning experience for me also. That's the greatness of this webinars. You get to learn so many things, and it's always been a learning experience for all of us. Whether we be lawyers, whether we judges, it's always every day is a new day. Every day, every experience is a new experience, and for that, I must thank Mr. Nankani. Thank you very much, and thank you, Mr. Shah and Mrs. Badeka for inviting me and to be part of this deliberation today. Thank you very much.
So my privilege, sir.
Now I request Joint Convener of Law and Representation Committee, Aditya Surte, to make a few announcements and offer a hearty vote of thanks to Lordship and today's speaker.
Thank you, President. Am I audible?
you are audible.
Yes. Before I proceed to offer vote of thanks, I would like to make a few announcements of the association. The first announcement is that the GSTPAM referencer, which is used by so many of us, is available for booking. Please book your referencer at the earliest. The next announcement is that the first outstation online seminar has been organized jointly with the Tax Practitioners Association Parbadi, and it is today at 3 p.m. Sports and Fitness Committee has organized online yoga session from 8 a.m. to 9:30 a.m. tomorrow. Please join the session. The next announcement is that the Maharashtra State GST Bear Act rules and the gist of advanced rulings that has been published by our association along with Taxman. It is one of a kind publication in the current scenario. This Bear Act is selling very fast. The early bird discount is expiring on 31st of July. Please book this Bear Act at the earliest to avoid disappointment. Next, we have organized a 5-day learning series on basic to advanced Microsoft Excel from 1st of August. The session will be from 6 p.m. to 7:30 p.m. We have also organized a 5-day lecture series on introduction to customs law from 8th of August. All of us practicing in GST, we've all understood in the first 3 years that we need to know at least the basics and then the advanced nuances of the customs law. This series is one step towards that. We have also organized a 4-day session, 4-session series of panel discussions on GST from 17th August. And the last announcement is that the online chess tournament has been organized on 6th of September. The details of all these events are being shared with the members on WhatsApp from time to time. You may also visit our website www.gstpam.org for more information. I now proceed to the wonderful task of offering a vote of thanks. With the advent of social media, the information is now freely and abundantly available. However, the risk of incorrect or half-baked information is also grown multifold. In this context, it is more important than ever to minutely analyze such landmark judgments and understand their implications. I remember many messages on social media after the Calcutta Club judgment had come out with headlines such as principle of mutuality upheld by the Supreme Court or no GST on clubs anymore. But now, after going through today's session, we know that there is more to the Calcutta Club judgment than what was first made out. We are extremely thankful to Sri Vikram Nankani sir, senior advocate, for enlightening us on the finer aspects of the judgment. We are also very grateful to Honorable Justice Sri Ujjal Bhuyan sir for not only blessing today's event by his presence and wisdom, but also showing his enthusiasm towards continuous learning by staying for the entire event and being a part of all of us. I also thank all the members for joining today's inaugural study circle meeting. Thank you very much. We intend to continue such learning experience throughout the year.
Thank you, sir.
Thank you.
Thank you.
Thank you.
Thank you. Thank you, sir.
Chalo bhai, thank you to everybody.